Hello again. Today we're going to focus on our next topic called employment arrangements. You are now aware of what employment relations mean in the context of work and employment, the actors involved, and the challenges that continue to evolve in this area of public policy regulation. In this topic, we look a bit closer at the different forms of employment arrangements that workers may experience. We will also look at issues of wage compliance, as well as unfair dismissal regulations for when a worker is dismissed from employment in a harsh, unjust, or an unreasonable way. So by the end of this topic, you will have knowledge of different types of employment arrangements that workers can experience, as well as know when a worker may be treated unfairly when it comes to the termination of their employment. As you can see, there is such a range of employment. This includes more traditional secure forms of work, such as permanent, continuing, full-time and part-time employment. These forms of work offer job security, usually set regular hours, set pay, and various other conditions such as leave benefits. You have a lesser chance of losing a job that falls into these categories compared to more non-secure forms of employment. Employment that offers less security is casual forms of employment, where hours are allocated by an employer based on demand. Hours can increase during busy periods and decrease during downturns. Casual forms of employment do not offer security, as they offer no guaranteed number of hours of work. However, the hours of work may not be regular, and you don't receive benefits such as sick leave or holiday pay. However, you will usually receive a loading to compensate for this and have access to unpaid carers leave, domestic violence leave, and community service leave. Employees can make a request to an employer for casual conversion to a permanent position after a certain period, usually about 12 months. There are certain rules around this set out in the Fair Work Act 2009, and an employer can refuse and must provide employees with a written response detailing the reasons as to why. A 0 hours contract is where an employer provides no guarantee of hours. Internships should offer experience in terms of training and skill development, and not be doing productive work that would indicate an employment relationship is present. The benefit of the internship arrangement must be with the intern and not with the employer. Volunteering is where the volunteer does not expect to receive monetary benefit and is under no obligation to turn up to the workplace. This can become problematic if the workplace expects the volunteer to attend at specific times and may indicate then an employment relationship is forming. Contractors are self-employed and manage their own hours of work and entitlements. They provide their own equipment and tools to perform work. Sham contracting, however, can occur where an employer may disguise what would normally look like an employment relationship so that they can avoid payment of certain employee entitlements, such as leave and superannuation. Underemployment from an individual perspective is where an individual does not have enough hours of work to meet cost of living and economic needs. And unemployment is where a person who is actively seeking employment is not employed. The Australian Bureau of Statistics considers 1 hour of paid work per week as being employed. We touched on the range of instruments that regulate the employment relationship earlier in this module, such as the National Employment Standards, modern or industry awards, and enterprise agreements, which can also be called collective bargaining agreements. Some employees may also be employed under a common law contract, which is an arrangement between the employer and employee, and often these contracts are for high-earning professionals. There are differences in terms of pay rates for junior employees, casual employees in terms of loading arrangements to compensate for such entitlements as leave, as we spoke about earlier. It is also important that if an employee is working additional hours outside of their normal working time or ordinary hours of work, then overtime is paid, usually at a higher rate. Penalty rates can be paid when an employee may be working on a public holiday or a weekend, or paid an additional hour for working a late or early morning shift. All of these are detailed within an industry modern award or an enterprise agreement. There have been cases where employees have not been paid their proper entitlements, and there are cases of exploitation by employers. You may hear the term wage theft used by trade unions. Cases have come up to light where employees were underemployed because they are fearful of losing their jobs, and this affects vulnerable groups such as migrants, and it can happen across a range of industries, including jobs in the platform gig economy. It is important to be aware of your entitlements, and if you are unsure, you can contact the Fair Work Ombudsman. While there are arguments to suggest the industrial relations instruments used are too complex for employers to ensure they are compliant, there have been specific examples of cases where cash-in-hand payments and failure to pay penalty rates have occurred and businesses prosecuted for underpayment. This has implications for the reputation of the organisation. It is also important to be aware that there are provisions regarding unfair dismissal and terminations under the Fair Work Act, and that there are different rules around this depending on how long you have been employed and if you are employed by a small business. Employees do have a range of protected rights under the Fair Work Act. For example, an employee has the right to be a member of a trade union or other industrial body without the fear of being dismissed from their employer, as well as also having the right to be free from discrimination. Complaints around unfair dismissal can be made via an application made within 21 days of the dismissal to the Fair Work Commission. An example of unfair dismissal can be you being forced to resign from your employment or being sacked in a manner that is considered harsh, unjust or unreasonable. An application to the Fair Work Commission may result in a conference between the employee and employer to help resolve the dispute. Where disputes are not resolved at this stage, the matter can then proceed and be heard by a member within the Fair Work Commission. Note that a similar process occurs under state-based regulations. So in this topic, you have learned about a range of employment arrangements, as well as how the industrial relations instruments play an important role in regulating pay and ensuring compliance, as well as understanding issues around unfair dismissal. However, there are issues of non-compliance, and organisations need to ensure that they follow regulations correctly to ensure fairness of pay and entitlements to employees. And you have also become aware that there are mechanisms in place for situations where employees have been unfairly terminated from their employment. Here are the references that have been used to support this topic you have learned about today. Thanks again for listening.